versus United States Citizenship and Immigration Services. Ms. Is it Niffen? Whenever you're ready.
Good morning, and may it please the court. My name is Margot Niffen for the appellants. Your Honors, the question before the court this morning is simple. Should United States citizens have the same access to the benefits of their citizenship, and in this case, the ability to seek family reunification, regardless of how their citizenship is obtained? The answer to this question must be yes. However, the special immigrant juvenile provisions of the INA contain an exclusion clause that USCIS has interpreted to mean that citizens who naturalize through this process are unable to petition their non-abusive parents for lawful status. This interpretation is arbitrary and contrary to the plain language of the statute, or alternatively, it violates the Equal Protection Clause as to non-abusive parents. I will start by addressing our arguments under the APA. The language of the exclusion clause states that no natural or adoptive parent of an alien, provided SIJS, shall thereafter, by virtue of their parentage, be accorded any right, privilege, or status under the chapter. The plain language of the statute, therefore, expressly indicates that it only applies at the time that the child is an alien. Our inquiry can thus begin and end at that point. Once the child is a United States citizen.
Why would Congress have to draft a statute that would bar aliens from acquiring benefits that would be available to their parents? It seems inconsistent. I mean, by definition, an alien would not have any rights to parentage benefits. So that doesn't make any sense.
Well, there are some privileges. There are, for instance, in this case, Mr. Fuentes was, as a lawful permanent resident, he could have applied for his mother to seek parole in place.
Is a lawful permanent resident the same as an alien?
A lawful permanent resident is an alien.
Okay.
So an alien is defined as any individual who's not a citizen. And so, for instance, the exclusion clause could have prevented it, under the correct reading of the exclusion clause, it could have prevented him as a lawful permanent resident it could have prevented him to seek parole in place for his mother at that time. However, once he becomes a United States citizen, pursuant to the plain language of the statute, the exclusion clause should no longer apply to him at that time. And that's exactly what happened in this case. In this case, he did apply for his mother after obtaining citizenship, and his parole in place application was denied for his mother. Similarly for Mr. Ayala, he applied at the time that he had obtained citizenship, he applied for an I-130 to seek to petition his mother, and it was denied.
Let me ask you this, because I think I want to make sure I understand your argument, because so your argument is that they're limited in time. This exclusion clause, I guess, is only applies between the time of receiving, I guess, the legal permanent resident under the SIJ, and after 5 years, you can apply for citizenship. So you're 5 years at the earliest. So you're saying that the exclusion clause only applies during that period of time?
Exactly. Exactly, because of the plain language of the statute.
But I guess my next question is, so under the statute, I guess you're saying that Congress drafted this language and it only applies from the time of receiving, I guess, the SIJ status. And applying and becoming a citizen, right? Which could be as early as 5 years, right?
It could be, well, depending on, the process can take a lot longer.
But the earliest
But
would be
the
5 years.
earliest could be 5 years,
Yes.
exactly, yeah.
So, but that, during that time, you would not be able to apply they would not be able to apply for status for the parents anyway, except for maybe one or two exceptions, the parole in place, like Fuentes, and maybe one other, but so you're saying Congress put that language in there just for those narrow situations?
Well, it's, the parole in place program is one program, but it is rooted in deferred action, which is actually a broader authority of the executive branch, and it can be applied to different programs based on an administration's priorities. For instance, the DAPA program, or we saw under President Biden, there are a number of prosecutorial discretion memos. So based on the priorities of administration, it actually could be a lot broader than specifically the parole in place program that Mr. Fuentes applied under, which was specific to military members.
Are you making a facial challenge to the statute or as applied?
It's so specific to the equal.
No, are you making a facial challenge or as applied challenge to the statute? That's a very discrete question.
It's as applied, in violation of the Equal Protection Clause, as applied to non-abusive parents, which is so there are two alternative arguments. If the court,
Why would it apply to abusive? Why wouldn't it apply to abusive parents in the past? You make that distinction. Where in the statute do you carve that out? They're treated differently. You say they should be treated differently, but then you say abusive parents should be denied that. How do you read the statute for that division?
so in 2008, under the TVPRA, the language of the statute was amended. Before that time, individuals had to show, in order
Have
to be
both
eligible
parents,
for
right.
SI, exactly, that they
Right.
had to show reunification with one or both parents was not viable due to abandonment, abuse, or neglect.
Okay.
And so since that time, an individual can seek SIJS and be granted SIJS based on only one abusive parent, and we see that in Mr. Fuentes' case. His mother was granted sole custody, and so she was the non-abusive parent. However, regardless of this change in 2008, and regardless of the importance of family reunification with the non-abusive parent, she was then still prevented under the exclusion clause from being able to be petitioned for, and for Mr. Fuentes to seek that petition for her and that family reunification for her. And so under the Equal Protection Clause, there's a distinction between United States citizens who are able to petition non-abusive parents and those who aren't. And the only reason is because of the individuals were naturalized
And
under
what
the
scrutiny do we give
SIJS.
to that? What
Excuse me?
scrutiny do we give? Is that rational basis or is that strict scrutiny or what?
It's rational basis.
All right, well, the change may have been to make it easier for the minor to get the status in terms of a protected child, because requiring both is a harder task. But so only one is required. That was for the benefit perhaps of the child, not for the non-abusive parent. Why is
Definitely.
that not a rational basis to critique? Because the point is, the child is eligible for a lot of benefits, for example, welfare benefits and those things that take care of the child, foster care, all of those things. And then the point is that was for their benefit. So whether you're an abusive or non-abusive parent, the child has received those benefits. And what they're saying is that after that, no parent are in the situation in that.
Yes, Your
Right?
Honor.
That's what it says, no parentage.
And that is so it's not the aspect of the statute that allows for one family SIJS, one parent SIJS. It's the aspect of the statute that then when the child does obtain status under the provision, that they cannot petition their non-abusive parent. And so that's the aspect of the
So
statute
whose
that we're
whose right is
challenging.
violated, the child or the parent, the non-abusive parent?
It's the child's ability to reunify and to seek
It doesn't-
petition their non-abusive parent.
That doesn't impact unification. It doesn't prevent the unification of the child. They can live with their parent, they can have all those things. How does that interfere with unification?
Because if the parent does not have lawful immigration status, they're constantly at the threat of removal, which creates stress for families. It creates, and, you know, for instance, in Mr. Fuentes,
What status have they been in before that?
these are parents who don't have lawful status.
I mean, what's their status in the country?
They're undocumented. They don't have lawful status.
So you're saying they're unlawfully here?
Yes, yeah. And so it's the
And
ability.
so the statute, you're saying the constitutional, their rights are violated? A person who is not lawfully here, the 14th Amendment equal protection, in that sense, does? You saying that? Is that your argument?
Well, the Equal Protection Clause does apply to both citizens and non-citizens,
Yeah,
but our
that's-
argument is that it's the right of the United States citizen child to seek that family reunification with their parent who does not have status. So after the child has gone through the abuse that they've experienced, the 10 years potentially plus of obtaining their citizenship through this program, they should have the ability then to petition their non-abusive parent for lawful status in order to seek long-term reunification with that parent.
But I thought under your interpretation of the statute that it would also allow a new citizen under the statute to petition the abandoning and/or abusive parent to gain benefits as well. Is that not your position?
Under the APA, and so there are two alternative arguments. If under the APA, the court agrees that USCIS's interpretation is arbitrary, it would mean that individuals, once they become citizens, have the ability to petition both parents. However, there are many safeguards in place that USCIS at that time could make that determination of whether the parent was abusive or not abusive. For instance, in the I-360, when the child petitions for their parent, they have to identify which of the parents they were, granted custody under, and which a parent was abusive or neglectful.
Well, there may be some differentiation at that point, but you're conceding, aren't you, that your interpretation doesn't make, at least initially, a distinction between the parents? Abusive, abandoning, good, bad, it doesn't matter, under your view?
Under the APA, if we read the plain language of the statute as drafted, it would not, the US, once the child becomes a United States citizen, they would be able to petition either parent. I would point out that this court in Perez Cuccinelli, however, indicated that the viability of reunification when looking under the CIGIS provisions is not permanent. And so there can be situations that when a child obtains SIJS, there is an abandonment finding as to one parent. However, the viability of reunification doesn't have to be a permanent finding. And so 10 years down the road, there could be circumstances where the child can then reunify with that parent based on changed circumstances, and that reunification is always in the child's best interest.
Now, you conceded in response to Judge Gregory's question that as to your constitutional argument, this is a rational basis analysis. And so, my understanding of that test is that Congress can legislate, and in legislating, either be over-inclusive or under-inclusive with respect to the rights or detriments that attach to a particular statute. And isn't this sort of a classic example of that? You make some compelling equity policy arguments as to why it seems unfair that a non-abandoning parent would be excluded from the statute, but that's the very definition of rational basis. Some people are harmed, some people are benefited, but so long as Congress legislates rationally, and that's a pretty low bar, that's all you need. So where's the violation? Where's the constitutional violation?
So under the rational basis test, it is a lower bar, but it still does provide some support. And it's not toothless. As the Supreme Court explained in Claiborne, it can't be based on unsubstantiated fear. Here, the government has provided no rational basis at all to exclude the non-abusive parents from the importance of family reunification.
I thought they cited fraud, that the concern that people would intentionally maybe abandon children for purposes of coming back and filing it under your theory. I thought they did cite several reasons.
They cited those reasons. However,
My guess is you don't believe that those will survive rational basis?
we don't believe that those survive rational basis. And
Okay, tell us why.
Yeah. The reason for that is it's important to look at the SIJS process as a whole. The SIJS process is a unique state-federal partnership. And in that way, it's unlike any other process under the INA. Congress has created a number of safeguards to prevent any fraud. The first step of the SIJS process is that you have a state court making the determinations that reunification is not viable and that returning to the child's home country is not in their best interest. Congress acknowledged that state courts are in the best position to be making these determinations. The rules of evidence apply. There's a credibility determination. There are often home visits. And so there is a whole system set up under the state court process to make these determinations. After those determinations are made, the child then has to apply before USCIS. And again, they're put through a whole separate process where CIS looks at everything that was before the state court, and then it makes its own bona fide determination that SIJS was sought for the purpose of escaping abuse and not to seek immigration status. Again, CIS officers can interview individuals and their family members. They can request evidence. And so there are a number of different safeguards in place that Congress created to root out any fraud. And I'll point out, in addition to that, once the I-360 is granted, there continue to be safeguards in place through the adjustment of status process, through the naturalization process. At any time during this sometimes more than 10-year process, an individual fraud could be detected and an individual could be removed, the status could be removed. And so there's so many safeguards in place that this idea that individuals will be defrauding the system, again, without any sort of evidence that this is happening is far-fetched.
All right. Thank you, Ms. Niffen.
Of course, thank you.
We've got some time left for rebuttal.
Good morning, Your Honors, and may it please the Court, Elizabeth Spavins, Assistant United States Attorney on behalf of the United States Citizenship and Immigration Services. This case involves a question of statutory interpretation of the clear language of a provision of the Special Immigrant Juvenile Statute known as the Exclusion Clause. As has been discussed already this morning, the SIJ statute or SIJ classification provides a pathway for an alien child under the age of 21 who has been found by a state court to have been abused, neglected, or abandoned by one or both of his parents, and thus is declared dependent on the court or whom the court has placed in the care of someone appointed by the court, and whose best interest is not to be returned to his prior country to obtain lawful permanent residence and ultimately naturalization. Under the exclusion clause of the SIJ statute, no natural parent or prior adoptive parent of any alien provided special immigrant status shall thereafter, by virtue of such parentage, be accorded any right, privilege, or status. The district court properly concluded that this clause applies to the plaintiff's mothers here because they are ineligible to obtain immigration status based on their U.S. citizen children.
So the statute essentially creates different classes of citizens, right, with respect to benefits? I mean, is there any other regime where that's the case?
Your Honor, I have two answers to that. First, the lens through which to view the exclusion clause is the rights accorded to individuals seeking immigration benefits, in this case, the parents, not the U.S. citizen children. And I would point the court to a couple of sources here. First, there are numerous statutes. There are other statutes that limit the ability of a U.S. citizen to petition for an immigrant relative based on aspects of that relative's status. And
So I'll let you finish that answer, but you just made a statement that suggests that perhaps the benefits being sought here are not benefits by the parents, but by the children. You say they petition. They're the ones that petition for their parents. Doesn't that suggest that this is a benefit that inures to the new citizens, not the parents?
No, Your Honor, this is an immigration benefit to the parents. This statute legislates and draws a line to individuals that can obtain benefits on their own behalf. It is certainly the case that the petition itself is filed by a U.S. citizen for a parent or another immigrant relative, but that is to obtain the benefit on behalf of the beneficiary, which is the parent. So I would point to the statute that limits the ability of a U.S. citizen based on age to petition for a parent. The person has to be over 21. That has survived court review. We cited the cases in our brief at pages 39 to 40. In addition, an individual who is engaged in marriage fraud is thereafter forever prohibited from obtaining benefits, regardless of whether they have a U.S. citizen child or not. So the exclusion clause is a line drawing statute regarding the provision of benefits to the immigrant parents who are seeking immigration status based on their parentage. And so for that reason, that is the proper lens to view with which to view this statute. We cite the RV versus Mnuchin case in our brief, which is another example of U.S. citizen children arguing that their rights were impacted because of the immigration status of their parents, and the court's analysis illustrates that the proper lens with which to view these line drawing statutes with regard to immigration benefits is the person who is obtaining the benefit. In addition, there's no dispute that rational basis applies here, so even if the court were to view this as a distinction somehow with regard to the U.S. citizen, for numerous reasons, this survives rational basis review.
So let me ask you about that. So the statute has evolved, and now we have this process by which the state juvenile courts first make these findings with respect to the status of the parents and who's an abandoning or abusive parent and who's not. That would seem to suggest that there was some reason for making that distinction, but then the statute then ignores all of that and says it doesn't matter who abandoned, who abused. We're not going to make that distinction. Everybody is going to be excluded. That seems a little bit odd, if not irrational.
Your Honor, I would respond in a couple of ways. First, the revisions in 2008 actually don't instruct or require state courts to determine who is an abandoning parent and who is not. It is certainly the case that in the case of Mr. Fuentes, his mother was awarded custody, so there's and so it seems clear that the father is the abandoning parent in that instance, but that's not required under the statute. For example, for Mr. Ayala, the state court determined, only said, I'm finding under the statute that one or both have abandoned, abused, or neglected. The court didn't there's nothing on the face of the court's decision that indicates it was only one parent, and indeed this is in the joint appendix, the underlying paperwork and motion that was filed to the state court actually discusses both parents' conduct, and Mr. Ayala was, his custody was awarded to his uncle, not either parent. So first I would say the amendment of the statute doesn't actually result in the state court making a determination about one parent versus the other. So that's the first answer. The second answer is that Congress could have had many reasons. There are many rational reasons to support the exclusion clause as written in its plain language, which did not change when they made the 2008 other change. So first, it can be inferred under canons of statutory interpretation that when Congress changes one thing but not something else, that they chose that. They could have changed the exclusion clause, but they didn't. Second, there are other reasons that there are rational reasons that Congress could maintain the exclusion clause as written, notwithstanding the broadening of availability of benefits. As Judge Gregory pointed out, the 2008 amendments they make it a little easier for a child to obtain SIJ status, but that is a rational basis on its own. The 2008 amendments do not need to be supported by also concomitantly broadening the application or broadening the availability of benefits for parents. Congress could, as we noted in our brief, Congress could rationally create an immigrant classification that opens the door to some people but not others. So they can open the door to children while deciding that that special vulnerable population deserves benefits but not another population such as their parents, number one. Number two, the rational concerns about fraud and potential abuse of the system may persist regardless of whether it's one or both parents. And so there are numerous rational reasons that survive the conceitedly low bar of rational basis review.
I suppose Congress could have just eliminated the program altogether or not created it, right? And
Certainly, what we are tasked with is reading the language that Congress wrote and has left in place since 1990, which is this exclusion clause. But that's right, Your Honor, there's no argument here that Congress has to have an SIJ program at all.
right, but once having created it, at least they still would have to satisfy Congress, a rational basis for making this distinction. So for example, if the statute had said that only the parents of children who were born in the month of June would be allowed into the country, you would concede maybe that's a little bit irrational? Even that might not pass the smell test?
I don't think, taking the court's hypothetical, I don't think the statute as drafted is anywhere near that.
I didn't say that. I'm just asking you about
course.
that example.
Rational basis review is certainly review. It is not a rubber stamp or a blank check to bless anything that Congress does. Nevertheless, some amount of overbreadth, over-inclusiveness, under-inclusiveness is permitted, and indeed, the standard is that it has to be any reasonably conceivable set of facts that could provide a rational basis for the classification. Here, that is satisfied. I don't know that a limitation.
And what are the facts? What are the facts that support? Because your colleague on the other side said there's just no factual basis for this distinction.
Sure. So the set of facts, which is, again, it's conceivable. It doesn't have to be a set of facts that Congress spoke about or articulated at the time. It's simply standing here today, is there a conceivable set of facts? So the first is it conceivable that Congress could create a program for benefits that draws a line between children and their parents? Yes, that is a conceivable, reasonable, rational basis to support immigration benefits line drawing. Numerous courts support the general proposition that when this line drawing happens in statutes, it survives rational basis. Number two, the possibility of fraud in the system and or abuse of...
Opposing counsel says that there are safeguards in place. That argument is not rational because there are safeguards in place throughout the process, throughout the family court process, that would prevent fraud, therefore making your fraud argument irrational.
Right. The first answer I would say to that is there's no reason that the exclusion clause isn't just yet another statutory safeguard against fraud. Statutes can be can have, overlap belt and suspenders approaches. There isn't any canon of statutory interpretation that says because the statute has some safeguards against fraud that other safeguards against fraud are therefore irrational. The exclusion clause is designed, like other safeguards, a reasonable set of facts supports the exclusion clause because, for the same reasons that Congress may have enacted other safeguards against fraud, this is one of them as well. It's not only fraud, it's also the potential for abuse. A conceivable set of facts is that an abusive parent then, years later, continues that abuse and asks the child to petition for benefits on their behalf. Congress may have wanted to prevent that possibility. I don't think the safeguards that opposing counsel pointed out necessarily address that issue because that set of facts contemplates that nothing has changed about the abusive parent at all. So no amount of safeguards against classifying that person as abusive would change the availability of benefits. And I would again point out that there's no basis and plaintiff appellant's argument concedes this. Their argument in no way distinguishes between abandoning and non-abandoning parents because the language of the statute simply doesn't bear that distinction. And so, indeed, under their argument, they would be opening the door to this possibility of abuse of the system, and there would be nothing to stop it because the plain language of the statute doesn't contemplate any difference between abandoning and non-abandoning parents. And again, when Congress did expand one aspect of SIJ, they did not expand this, and this court may one of the canons of statutory interpretation is that this court may interpret Congress's silence as evidence that they intended not to change the exclusion clause. Briefly returning to my statutory interpretation points, I just wanted to return to a number of canons that support the plain language interpretation here. Plaintiff's argument focuses on the word alien out of context, which is not how this court interprets statutes. Rather, the term alien is viewed in the context of all the other words in the statute, which this court should give meaning to. In particular, the phrase shall thereafter is rendered a nullity under plaintiff's argument. In addition, the clear language that parents by virtue of such parentage be accorded any right, privilege, or status, that broad language is not given meaning under a plaintiff's proposed interpretation. Indeed, plaintiff's interpretation would render this exclusion clause extremely limited which is another problem with their interpretation, as this court was asking before. Under plaintiff's argument, both the only preclusion or exclusion here would be abandoning or non-abandoning parents petitioning for benefits during the window in which the child has become an LPR, but before they are a citizen. Plaintiff appellant has only pointed to one benefits avenue in that instance, which is the parole in place. There, notwithstanding the other hypotheticals about what different regimes could, different schemes that could be thought up with regard to benefits that a lawful permanent resident could petition on behalf of their parent, the only one that's identified in this case is the parole in place. Really, the benefit of being a lawful permanent resident, you can't petition on behalf of your parent with an I-130. You have to be a citizen. So that plaintiff's reading really significantly narrows the exclusion clause, which is divorced from the plain language, the clear plain language of no parent, any alien, and shall thereafter. In addition, plaintiff's argument would result in the absurd result, again, of allowing both parents to, the citizen to petition for benefits for both parents, and there's no reason to think that the statute would support that reading. If the court has no further questions, we ask that the district court's decision be affirmed. Thank you.
Thank you very much, counsel. Ms. Niffen?
Just wanted to briefly point out that opposing counsel mentioned for Mr. Ayala that it was unclear from the record which a parent was abandoning and which was not. And there was actually, if you look at the findings of the state court, it's specifically on page 47 of the joint appendix, it's clear that while the finding of abandonment was specific to his father, while there were findings that his mother couldn't care for him, it was clear throughout the record that the father was the abandoning parent in that situation. And I think that regardless, even if it would be unclear from the record in that case, it could be denied, the status could be denied, the petition of the parent could be denied if the record was unclear from CIS. I also wanted to briefly address the issue of line drawing that opposing counsel brings up, that it's that line drawing and the legislation, immigration legislation, is a rational basis. And while Congress can pass laws to legislate around immigration, once those lines are drawn, individuals from the same group cannot be subjected to disparate treatment, disconnected from a rational government interest. And so that is, to the extent that that USCIS is trying to water down the rational basis test to say that, that Congress can legislate, there still needs to be a rational basis. And that's what we don't see in this case.
Go ahead.
No, go ahead, Chief, please.
Your colleague gave at least one example that I recall of distinctions and limitations with respect to benefits accorded citizens, one related to age and being able to petition certain, parents or relatives based on age, and that seems to have survived judicial scrutiny. So it seems like Congress can make those distinctions, no?
Again, Congress can make those distinctions, but once the distinctions are made, individuals within the same subset cannot be subjected to different treatment. And so in this case, individuals who are United States citizens cannot irrationally be subjected to disparate treatment solely because of the way they naturalized. In this case, because of seeking naturalization through the SIJS provisions. And so that's the distinction here. And courts have always acknowledged that while Congress does have the authority to legislate around immigration, there is still the rational basis
Well, based on
does
that,
provide support.
then they shouldn't be prevented from having abusive parents as well get the benefit.
So
It would have to be the logical extension of the argument, right?
as to abusive parents, there could be a rational basis.
Oh, really? Why? Why? The child is now an adult, and they're reunification, and like I said, people change, and I think you were alluding to that before. Why? Because that's your argument. So once you receive that, then it should be any difference. And why should it make a distinction? You can have the benefit for the abusive parent, just like you could a non-abusive parent.
For the non-abusive parent, there could be more.
I'm talking about the abusive parent. On the abusive parent, why shouldn't they be able to? Under your logic, they should be able to do it. You said should be no distinction. They're a citizen. Why shouldn't they be able to have the former abusive parent receive that benefit?
Well, again, I think that because there is a history of abuse, there could be more of a rational basis than for the non-abusive parent when there's no basis in the record of abuse. And again, there are multiple safeguards in place that Congress has created to determine that parent is not, there's no basis, there's no history of abuse that would prevent that child from petitioning their non-abusive parent.
There are all kinds of safeguards. Isn't it true that since this is a collaboration between the federal government and the state government, i.e. juvenile domestic courts, right? That's where it happens. the child, that doesn't have to be a parent at all. A child could be determined to receive this benefit by the fact that nobody is here to represent this child. And therefore, since we know the child was born, therefore you have to be born, you have parents, and none of them are here, so now you're an abandoned child, right? Is that right?
That's right.
All right, so then no
parent.
parent is right, right, so under your rule, then, either parent could come up later and say, I've never been found abusive, then I get this benefit, right?
That is correct. If there's no finding, yep, that
But
is
that's,
correct.
but isn't that the part of the thing, that the rational basis, is the point is that once we do it here, then we don't get into trying to figure out who is abusive and who's not, and those kind of things. Once the benefit is there, I mean, for the child gets the benefit, then it's whether or not the other person, we don't have to go back and find out what your status is. If you're a parent, you can't get the benefit by way of this child. That's what Congress wanted. Line drawing is that way. That's why a rational basis is that, listen, the child has been taken care of. Or, like I said, welfare benefits, the state provides those, right? That comes out of the state's coffers, not just not the federal government necessarily. And that's done, and then now somebody comes and says, okay, I wasn't abusive, nobody found it, so this child now can help me to become a citizen. And Congress said no. For whatever reason, because you can abandon a child for a good or bad reason. Matter of fact, sometimes for love, people abandon their children. They said, I can't take care of this child. Please, somebody step in the breach, right? So that sense, everything's a negative abandonment. You don't know what that is. So Congress said, let's give this child what he or she needs. And it's not going to be later leveraged for another benefit for a person who's a parent, because you can't go back and figure that out. And that's what rational bases are. You mentioned the word line drawing. I think that's what Congress does, and it does it in many ways. But go ahead, time is out, and the Chief is very indulgent. I appreciate that, but I'm sure he'll let you.
Yeah, please
Yeah,
respond.
I think that I would respond by saying that family reunification is always in the best interest of the children. And at bottom, the SIJS provisions were always created at every step in the statutes, many amendments. They were always created to protect vulnerable children. And especially the 2008 amendments under the TVPRA were meant to expand and to further protect these vulnerable children. The ability of these children to reunify and to seek permanent stability is, again, because these children have been through a history of abuse. That is always in the best interest of the child at the end of the day, to be able to reunify and seek stable relationship with parents who did not abandon or abuse them. And because that is the purpose of the statute at the end of the day, that is the best reading of the exclusion clause.
All right, thank you, counsel.
Thank you so much.
I want to thank both counsel for their fine arguments this morning. We'll come down and greet you and then move on to our second case. Our second case is 25-1449 Jackson versus Bush. Mr. Hawkins, whenever you're ready.
Morning, Your Honors, and may it please the court. Your Honors, well, my name is Josh Hawkins on behalf of the appellant, for the record. Your Honors, the backdrop of this story is fairly important, so I'll just take 30 seconds to give the court the backdrop. Mr. Simmons, the decedent in this case, was housed at the South Carolina Department of Corrections from 2016 to 2020. During that time, he was repeatedly attacked, including at least 4 stabbings that we know of. I'm personally involved in litigation in 3 of those. These attorneys are involved in those 3 cases. During that time, it's important to remember that this is kind of particularly tragic because his co-defendants' charges related to weapons and burglary and that sort of thing were overturned. So there's a good chance that his conviction was going to be overturned, but he was in SEDC, he was repeatedly attacked. At one point he says, "Do I have to die for somebody to take this seriously?" So that's all important because he had requested protective custody. And he was in F2 unit when he was fatally stabbed. What we're going to talk about, he was in F2 unit, which is where the people were sent who requested protective custody. So when Bush, the primary culpable person that we're going to talk about, the guard, when he goes down to F2 on the day in question, he knows subjectively that everybody in here is potentially a target. They've all been attacked. They've all been targeted. This is a vulnerable group of people.
Does he know about Mr. Jackson's particular history?
He does not know specifically about Mr. Jackson, but he knows that Mr. Jackson is one of the many vulnerable people that he has a duty to. And we know from Cox versus Quinn that you have a duty to protect inmates from the danger of other inmates. And we know from Farmer that when somebody's vulnerable, like all these people were, all these targeted people who had protected PC, you have a duty to protect those people, even if you don't know the exact assailants. That's what happened for him. And so when he goes down there this day, he knows that, 1, everybody's vulnerable. 2, he's in a maximum security facility full of dangerous people. And he knows that all these people who were locked up are not supposed to get out of their cell unless there's a reason to let them out.
Before you keep going, I thought there was testimony from, is it Officer Bush, that he didn't know that Simmons was being threatened?
No, there's testimony in the record, Your Honor, that he didn't know specifically that Simmons was being threatened, but he knew that F2 is where vulnerable and targeted people were housed. So he knew that everybody in there was a potential target. And so he didn't know anything about Simmons specifically, but he knew that if he created an unreasonable risk, or if something was obvious and could easily be averted, and he took steps toward creating that risk, that it was going to be a near certainty that there was going to be a calamity and some sort of violence, because if he lets somebody out in an unauthorized way and mixes them with vulnerable people, then they're going to have, people are going to have access to the vulnerable people that are being targeted. So he has that subjective knowledge. The policy that required him to check the worksheet on the lieutenant's door would have prevented this. And of course,
I was looking through record. Which policy are you referring to? I know there's testimony that he was supposed to check the record, but which policy, written policy, are you referring to?
Your Honor, I can't point to the SCDC policy by policy number, but at 822 and 884 and 859 of the record, there's testimony about what he should have done. For example, Robert said that he's given oral testimony about the policy. What he was supposed to do if an inmate was wanting to be out for some reason was go and check this worksheet and make sure he wasn't letting somebody out who wasn't supposed to be out. He testified that he knew that inmates lie to get out. He knew about that. He knew that they make weapons. He knew that he was supposed to, he knew that everybody in there was vulnerable, like I said, and he could have gone and checked the worksheet, or he could have used the radio, or he could have asked an officer, the superior, hey, is this okay? Because we know that, in the Brown versus the North Carolina Department of Corrections case, if you know that a danger can easily be averted and you fail to do it, that's a fact for a jury to consider. This was not only easily avoidable, he had to take extra steps to make it possible. All he had to do was leave the guy where he was supposed to be, which was in his cell.
Well, let me ask you about that, because I don't think that there is any dispute that he did not check the record that day. But the two guys, I think Ransom
And
and Dominic, I think Ransom was a barber, and so even though he didn't check it, I'm assuming if he checked the list, he was able to be let out of his cell. And I think Dominic was he had some job also where he was able to be out of, would that not make a difference?
Well, Your Honor, it might to jurors, and McDessie versus Field tells us that jurors are the ones to make this decision. This is all circumstantial evidence for a jury to consider, because Dominic was not a barber, for sure. And he's
Yeah, I
one-
think, but he was like a ward keeper or something, and so he was able to
Right.
be released from his cell also?
Yeah, and those officers offered sort of some self-serving testimony on that issue. And that's all fair game for a jury to consider. But the jury, I think, has to consider, one, it's undisputed that the person who did the stabbing was not a barber. And two, it doesn't matter if they were both barbers or hairstylists or whatever. You don't just let somebody out because they asked to be out. You're in a maximum security facility. You only let them out during the time there's an authorization for them to be out. And if they ask to be out, you go and you do any one of these grocery list of things that you can do to verify that you're not about to create an almost certainty that there's going to be violence.
Mr. Hawkins, those are all great jury arguments, as you say, but you don't get to a jury unless you get past the qualified immunity test, which is intended to prevent defendants from being exposed to a jury where the
Right.
risk isn't subjectively and objectively identifiable, and the particular actions by the defendant that he was on notice that those were clear violations of the Constitution. So the problem is here that it's not. Well, maybe you can explain to me why you think otherwise. But how did Officer Bush understand that Simmons was subjected to a particular risk of death or injury by this particular inmate?
Well, Your Honor, there's not evidence that he was knowledgeable about that particular assailant or that particular inmate, but Cox and Farmer and all these cases tell us that's not the test. The test is, do you know about it? The test is, do you know about an injury? Do you know about a person being vulnerable? And he knew that it didn't have to be Simmons. It could have been any of these vulnerable people, because he knew that they all had requested PC because they were being targeted. So in that scenario, to go and then let out somebody on a suspicious request, and by the way, he belies his subjective knowledge that what he's about to do is deliberately indifferent, because he tells the guy, he says, all right, don't BS me now. Are you really supposed to be out? Well, you're talking to an inmate who's in jail. Of course he's going to tell you what he has to say to get out. So that hesitation belies his subjective knowledge that he's about to do something that's not in bounds. And the magistrate, Judge Hodges, she sort of says in the report and recommendation, well, it's negligence or gross negligence, but it doesn't rise to the level of deliberate indifference. Well, that's for a jury. Now she's weighing.
Well, we have this King versus Riley case.
Right.
That says that knowingly violating a policy doesn't, I think that's probably what she cited, doesn't necessarily arise to
Right.
deliberate indifference. And so I'd be interested to hear your response to
Sure.
the King. How do we get around the King versus Riley?
Well, we get around that, Your Honor, with the Brooks case or with the McKinney case, the Dean versus McKinney case. Dean versus McKinney was a police chase case, so it's a Fourth Amendment context, but it still looks at the analysis of a policy. And this court said in that case that violation of that chase policy was relevant in determining that qualified immunity did not apply, because it showed that there was no exigent circumstance in that Fourth Amendment context. Now, in an Eighth Amendment context, which is where we are today, we have I believe it's the Brooks case. it says the policy violations are highly probative or highly relevant. And we don't take the position that a policy violation equals a constitutional violation, but we do take the position, Your Honor, that along with all these other factors that we're talking about, that's evidence for a jury. So if there's a policy, hey, you don't let people out of their cell just because they ask. If somebody wants out, you've got to go take these other steps or make sure they have an authorization to be out. That's relevant to a jury's analysis. You know, when I stand up, hopefully, when we go back and I talk to a jury about this, that's one of the pieces of circumstantial evidence described in McDessie versus Fields. McDessie didn't describe policy violations, but it did talk about, you know, it cited back to Farmer, it says, deliberate indifference is something that's proven in the usual ways with circumstantial and direct evidence. And here we got a pile of it. And it might be that they win at trial. You know, they might come and they get a jury and they say, look, there's no sufficiently culpable state of mind, and they might convince a jury of that. But a jury is entitled to hear about violation of written or unwritten policy, you know, disregard for the safety of these people who had requested PC, failure to check with supervisors, failure to use the radio, and then importantly, this is highly relevant, Your Honor, and highly probative, he turns his back on the situation. He lets the guy out of this cell on a suspicious request without consulting the list in a maximum security facility in the unit that's full of people who protect a PC who are vulnerable, and then he doesn't do anything for at least 6 minutes to even monitor the situation because Dominic is walking around with an 8-inch blade in his hand on film, on camera for 6 minutes. And nothing happens. Nobody intervenes. Now, there's not evidence that Bush saw the video of that, but Bush certainly created the scenario. And then, you know, he basically created a Hunger Games situation. You know, good luck. He let these people out, he let them intermingle, and then he didn't pay any attention. He went back to doing, you know, whatever he was doing, training MAP, I think it was. He was also the only person down there, and there was some testimony that when you're the only trained person down there, you know, other than the person he was training, he shouldn't have let anybody out of their cells. So there's conflicting evidence on that around 859, or I'm not sure which page of the record that's on. But there's some conflicting evidence around whether he should have let anybody out at all, much less let somebody out just because they said they wanted to be out of their cell. And so when you look at all this stuff in the aggregate, for sure, there's a lot of evidence by which a jury could conclude that there's deliberate indifference. There's no question about the second prong of the test. I mean, he died. He bled to death. He's covered in blood. Youngquist comes up to the door. They drag him over there. He's incapacitated, of course, been bleeding out for the better part of an hour. And Youngquist looks and she says, oh, well, I thought they were playing. Well, she didn't do anything to call help for anybody for several minutes, long enough for them to leave and then come back. And then by her own account, that's at least 2 minutes. Or she says that the encounter didn't last more than 2 minutes. But 2 minutes when somebody's bleeding to death, I mean, 20 seconds would have been too long to just say, oh, y'all stop playing. And a jury's entitled to hear the evidence about his appearance because he bled, so much blood came out of his body that he bled to death. So he didn't have a little bit of blood on his side. He was covered in blood and he was dragged there incapacitated by other inmates. And when the other inmates had left and come back, they said, hey, Youngquist, come on, open the door. They're pleading with her to do anything. And so we acknowledge that I read back through the brief and in researching and preparing for this argument, we understand that the arguments as to Robertson and Parks and Mapp, we might not get a deliberate indifference on those defendants. But as to Bush and Youngquist, we do because there's evidence of deliberate indifference from which a jury could conclude that there's liability here. And so what we ask the court to do is reverse this, send it back, and at least as to Bush and Youngquist, let us have a jury trial so that a jury can hear the evidence in this case, Your Honor.
All right, thank you, Mr. Hawkins.
Thank you.
Got some time for rebuttal. Mr. Lindenman?
Thank you. Thank you, Your Honor. May it please the court. My name is Andrew Lindeman. I represent the appellee, Gerald Bush. With me here today is David DeMasters and Russell Harder. who represent the other appellees, and I'm presenting the argument for all the appellees. In this particular case, and again, I'll start with some of the appellees other than Mr. Bush. I'm not certain that that was just a concession from appellant's counsel that they're unable to show deliberate indifference for Associate Warden Robertson and
It sounded like one.
it sounded like one, and Officer Mapp and Officer Parks. I'll say this very briefly. Obviously, the allegations against the Associate Warden, Mr. Robertson, are under supervisory liability. There are three distinct elements for that. There was no evidence presented that meets any of those elements, plus it's obviously, as this court has indicated, a very high burden. Ultimately, the same argument as far as Mr. Parks. Officer Parks was not even in the F2 unit. He was out on the yard on a golf cart. He received a message over the radio from Officer Youngquist that a stabbing had taken place. He drove immediately to F2 and assisted with getting Mr. Simmons onto that golf cart and took him directly to the medical department. Clearly, there's no evidence of deliberate indifference and a failure to provide medical care for him. Let me focus on Officer Bush and Officer Youngquist. The allegations against Officer Bush are obviously a failure to protect case. Both the magistrate judge and the district judge closely analyzed the evidence that was presented in this case and determined that there was no evidence presented to meet the second element of a deliberate indifference standard, specifically the subjective standard. And quite frankly, I know opposing counsel just told this court this morning that there's evidence that Gerald Bush was aware that F2 housed inmates who had requested and been denied protective custody. I don't believe there's any evidence in the record to support that. In fact, Officer Bush was not typically assigned to F2. He was typically assigned to F3. That particular morning, Officer Youngquist was running late. Officer Bush covered the first 45 minutes or so of the day shift in F2. He was directed to release inmates from the top tier as well as any type of working inmates, but there's no evidence that he was aware of the history of that particular unit, and certainly there's no evidence that he was aware of any history of that Mr. Simmons had either at McCormick or at previous institutions as far as other assaults.
If that unit had been his regular unit, you think the claim would still fail because of the lack of evidence, from your perspective, of a particular threat from the inmate who eventually killed Mr. Simmons?
Absolutely, Your Honor. And the main reason I'm
Well, I
making...
mean, your colleague on the other side says that that can't be right because by definition, all these inmates are there for a reason. They're at a heightened risk of harm, and officers should understand that and act accordingly.
Well, I would disagree. There still needs to be a specific risk, as this court indicated in case Judge Benjamin mentioned, the King versus Riley case, that simply having a general idea that there's violence in prisons, general risk of harm is not sufficient to establish a deliberate indifference. You have to have the specific risk of harm. In this particular case, there's absolutely no evidence that Officer Bush had any knowledge, number one, of Mr. Simmons having any specific vulnerabilities, any issues between Mr. Simmons and the other two inmates, Ransom and Dominic, and that there was no evidence that would suggest that any risk of harm was even obvious. And the district court did a good job, I believe, of going through that absence of evidence. I brought up the fact that there wasn't even knowledge by Officer Bush as to the type of inmates who were in F2 because opposing counsel indicated that there is. The only person who testified to that was the associate warden. Officer Bush did not.
Well, wait a minute, what, Officer Bush disputed that, right? That he knew that had previous, not allegations, but complaints that they're in danger, and that's why they were there. He disputed that, right?
My recollection, he was not even asked about the, and I may be incorrect about that, but I don't recall any testimony in his deposition where he was even asked about knowledge of inmates in F2. But he indicated that he was unfamiliar with F2 inmates because that was not his typical unit.
So he denied it then?
I'm sorry, Your Honor?
He denied any knowledge that these people were there because they were under threats. That's why they were there. He denied that.
Well, he denied having any knowledge.
He denied that he didn't have, that he had knowledge. He had no knowledge of their status while they were there. That's denial, isn't it?
I believe that's correct, yes, Your Honor.
That's disputed, isn't it?
Well, I don't believe so, Your Honor.
You just said that somebody else said that these people were there for that purpose, and he was there. So the fact is that that was their status. He says, I didn't know. We have to accept that as that's the case. And we don't take in Fourth Circuit, qualified immunity, we don't deal with that in terms of facts or disputes. That's a big part of this thing. Because the question is now, did he know whether he had individual problems with that person? What the allegation is that this area they were in, and the prison they're in, is so dangerous that people ask to be put there because they're in danger. And therefore, their theory is that it didn't matter which person might hurt you, all of those people, because were under threats, and that's why they were there. And therefore, you just let somebody out. And matter of fact, he should have known the danger because he said, well, are you sure? Don't be BSing me now. Are you sure you really? So in his head, so he knew that there was danger, and said you wouldn't ask questions like that. And then without checking the door, he lets those two people out, and they brutally murder this man in a matter of, not seconds, but a few minutes, right? And then he left the area. Matter of fact, he let them out, and he left the area, right? Well, he was called to another area, is that right?
When Officer Youngquist reported to F2, he went to a different unit, F4.
Yeah, so he had let this potential danger situation, and he left. So you're saying that's not a disputed fact? In other words, people don't have to confess. Like, okay, as long as I don't confess that I know, that's not a disputed fact. What it is, it's the series of circumstantial evidence and other evidence that says, yes, you did know. And that's what a disputed fact becomes from, right?
Well, yeah, I disagree. And just to clarify,
What do you disagree with?
This was not a protective custody unit, Your Honor. These inmates had not been granted.
I know it. They were there
custody.
because they hadn't been. They were in sort of, well, we can't put you in PC formal, but this is an area where if you sort of, we give you a heightened scrutiny, if you will, here. And then there's general population. So you're right, they weren't PC, but they were in that heightened area for a reason. And the evidence is, circumstantially, and others, that he should have known that and just let them out. And he in the record, he admits that he had some questions about it because he said, I just said, well, wait a minute, I'm not really sure. He's taking their word for it. Is that guy a barber? Matter of fact, he asked other people, is he a barber? Yeah, he's a barber, let him out. Isn't that right, counsel? Am I right about that? Didn't he say somebody said, yeah, is he yeah, he's a barber, let him out. Somebody else, another inmate said, yeah, he's a barber, let him out. Is that right?
Well, but as Justice Benjamin indicated.
No, I want you to get for the record of this appellate record here. Isn't that right? That's what he did. He asked if somebody said, verified, yeah, he's a barber, and he let him out.
Yes, he determined that from what he was told that they were barbers.
And he was told that by an inmate, right?
That's correct.
Okay.
Now, but ultimately, Mr. Ransom, inmate Ransom was a barber, and inmate Dominic was also entitled to be released because he was a ward keeper. He had a job as well. So, and the testimony, it was, the record has the face sheets for both of those inmates, which reflect those jobs. So ultimately, the district court took judicial notice of that information. It's undisputed. The plaintiff hasn't disputed that Ransom was a barber or that Dominic was an assistant ward keeper. So they were entitled to be out that morning.
The district court took judicial notice of that?
They took judicial notice of the face sheets that were, and they're in the record, in the joint appendix. The face sheets show a listing of the different jobs that these particular inmates held.
Did this
And
face sheet say what day they were out for those jobs? What day they were to be released?
the face sheets show.
What day they were supposed to be out?
The face sheet shows when they held those positions at McCormick Correctional Institution.
When they held the position.
That's right.
But does it show when they were allowed to be out of their cell?
Well, they were allowed.
Counsel, can you just answer? Just
Yeah, I understand
Does
that.
it show, I mean, it's a document that the court took judicial notice of. Does it say what date they were supposed to be out? You're telling me it shows that they are barbers or they have a job. Does it show when they were supposed to be out?
The face sheet doesn't include
what I
that
thought.
information.
It doesn't, I know.
It shows what jobs that they
What
held
difference
during
does
that
that make
period
if you have a
of time.
job, but you're not supposed to be out at the time that you were let out? So I don't think judicial notice does anything for that.
Well, there's no dispute that individuals who held jobs were allowed to be out of their cells that morning. That has not been disputed by the appellant. And so ultimately, the fact that those two inmates, Ransom and Dominic, both held jobs, they were entitled to be released from their cell, regardless of whether Officer Bush should have checked some list or not.
Now, just tell me, who testified to that?
Who testified to that?
That they
Both-
were entitled to be out at any time?
Both Officer Bush as well as, I believe, the associate warden testified as well. But ultimately, that was the purpose of what Officer Bush was directed to do that morning while he was waiting for Youngquist to get to work, was to release the top tier and release all inmates who were workers. And that would include Ransom and Dominic.
Mr. Lindeman,
Yes.
several of the inmates testified or gave statements that said that they heard fighting for about 40 minutes. Would Bush and Matt have had access to video monitors at that time?
I do not believe so. I don't know that it's in the record whether there were video monitors actually in the unit itself. Of course, at that point in time, Youngquist had arrived and Officer Bush had left to go to his assignment at F4. But ultimately, the video evidence does not show, and in fact, there is no evidence, as the district court found, that either Mapp or Bush, number one, were aware that Dominic had a weapon or observed Dominic with a weapon. So ultimately, that was an additional factor that the district court used in its analysis of whether or not there was deliberate indifference. Let me talk about Officer Youngquist. Officer Youngquist, as I indicated, was assigned to the F2 unit that morning. She was running late. So at the point that she was in the Sally Port, had gotten the keys and other equipment from Officer Bush, she was in the process of entering the unit when inmates brought to the Sally Port door Mr. Simmons. She didn't immediately perceive exactly what was going on, but within, the testimony was 2 minutes, she understood what was going on and immediately allowed them into the Sally Port, summoned medical assistance, summoned Officer Parks, who, as I indicated earlier, was on a golf cart, came to the F2 unit, got Mr. Simmons onto that golf cart and got him immediately to the medical department. Obviously, for a failure to provide medical care case, this is a case where they're alleging a delay in providing medical care. There's no merit to that. I mean, obviously, the delay in this case would be a matter of minutes. I mean, her testimony was 2 minutes. There's no evidence in the record to dispute that representation. And more importantly, there's no evidence of any substantial harm that was caused to Mr. Simmons from the fact that there was a minute or two delay in getting him out of the unit onto the golf cart and taking him to the medical department. There's no expert testimony, there's no medical evidence to suggest that there was any harm. So this is not a case where the appellant is challenging the quality or the scope of the medical care. It's purely a delay case. And as this court's case law, including the Webb case, indicates, you got to show substantial harm that resulted. I mean, even if 2 minutes would be considered an unconstitutional delay, I would submit to the court that it doesn't rise to that level. But bottom line is there's no evidence of any substantial harm. As far as Officer Youngquist as well, I would point out that the district judge found that the objections with respect to the allegations against Officer Youngquist were not specific. Ultimately, she determined that they were general objections, to which she then applied the clear error of law standard, found that there was no clear error of law, and obviously then adopted the recommendation from the magistrate judge. The appellant has not challenged on appeal the determination by the district judge that the objections were general and not sufficiently specific as far as Officer Youngquist. So that's an additional reason I would submit to the court that the summary judgment for Officer Youngquist should be affirmed.
Mr. Hawkins began his argument with a quote from Mr. Simmons along the lines, and I'm paraphrasing, what is it going to take for someone to be concerned about what's happening to me? And this, we're hearing this case in isolation. There was a related case that we continued involving another lawsuit filed by the estate of inmate Simmons relating to an assault. Somebody apparently threw him over a flight of stairs. He also had been assaulted allegedly in some other institutions. And I say all of that just because I'm concerned about this sort of looking at these cases in isolation. There seems to have been some kind of institutional default or neglect here to not recognize that this was somebody who was in grave danger. And it may be that Officer Bush might not have known about the particular danger, but why wasn't the institution on notice of what was happening here with respect to Simmons?
Well, I think the main point to respond to that is what you just indicated, Judge Diaz, is that there's no evidence that Officer Bush had any knowledge as to any prior issues.
Well, that may be, but Simmons is dead, and it appears to be an institutional failure.
Well, and ultimately, there's state court litigation that's pending to address those particular issues. I mean, obviously here, we're dealing with specific officers, what they knew, and whether or not they were specifically deliberate indifferent, not whether unnamed parties or the Department of Corrections as a whole was somehow negligent or failed to properly protect Mr. Simmons. The issue is these specific 5 officers, and really 2 as far as the failure to protect claims, and that's Officer Bush and Officer Mapp. And the evidence simply, as the district court found, does not support a finding of deliberate indifference as to those particular officers. Again, I can't speak to the institution or the department as a whole. And they're obviously not a defendant in this case, and there is other litigation that's obviously pending, as Your Honor has indicated. And those raise state court claims, not federal Eighth Amendment claims. I see my time is almost up. I would.
Well, it is up, actually.
Oh, it is up. I'm in reverse here.
Ask
I
my colleagues
apologize.
if they have any questions, additional questions.
Thank you, Your Honor. We would ask that the court affirm the district court's grant of qualified immunity and the ruling on the Eighth Amendment claims.
Thank you.
Your Honors, I want to sort of lead off so I don't lose track of it. There were some questions asked about whether or not these individuals, these assailants, should have been out. And my colleague indicates that it's undisputed that they were allowed to be out. I don't know where that is in the record, that it's undisputed they were allowed to be out. In fact, if I could point Your Honor's attention to the Joint Appendix 684, Youngquist testified that Bush should not have let any inmates out during the time that he was the only certified officer in the unit. She says, quote, "You're really not supposed to let anybody out when you're in a dorm by yourself." And by yourself, Matt was with him, but she was being trained. She was not a certified officer. And so, and we can look at Joint Appendix at 161, again, back at 684. There's a factual dispute on that. There is a factual dispute on that. And I'll also speak before I go to a couple other points in rebuttal, because Your Honor asked a question about the institutional failing and the backdrop. The first stabbing in this case, well, it was the second, but the first one we filed suit over, was so bad, the facts of that case were so bad that we got offensive summary judgment as plaintiffs, and they filed interlocutory appeal because we were about to go to trial, and we basically had a damages trial because there was so much overwhelming evidence, which to get summary judgment in South Carolina, it has to be a mountain. And we had so much overwhelming evidence, there was not even a fact question about their gross negligence. There's a fact question here in this case about deliberate indifference, but SCDC is a wreck. Every case we have, we find multiple policy violations. This case is no different. This person, Bush, I don't think took his job seriously. You know, he goes into a unit and just to march through the fact questions, the evidence in the record is that if the assistant warden knew that this is where everybody went that had protected PC, a jury's entitled to draw the inference. I mean, that has to be drawn in our favor. Jury's entitled to draw the inference. Well, of course you knew about it, Bush. If your boss knows about it, surely you know that this unit they sent you to on this morning has the people who have protected PC. And to go to somebody's, you're the only certified officer in there, you go to somebody's cell and they say, you know, it's cool, let me out, I'm a barber, or somebody else asked you to let them out and you just go and do it, and then you turn your back, you don't go check to make sure they should be let out, and then you turn your back on them and they're walking around with an 8-inch blade. I mean, Cox versus Quinn, and you know, the big seminal case of Farmer tells us you can draw deliberate indifference from the very fact that a risk is obvious. We don't need, you know, the Fowler case tells us this. You don't need something directly on all fours when it's this obvious. The Bryce versus Virginia Beach Correctional Center case tells us that you can't just say, I didn't know about the risk no matter how obvious it is. And I can't imagine a situation that would make it more obvious to any officer. And the question is, to a reasonable officer, would he have known that this would, you know, be an unreasonable act? I can't imagine a situation where that would be more clear.
But is it accurate that Mr. Lindeman said that this was not Officer Bush's normal duty assignment? He
Right.
was covering for somebody else.
Right.
So what's the direct evidence that he actually knew the circumstances of the inmates who were in this particular unit, other than the fact that it existed? But that could be true for anybody.
Well, Your Honor, I think the fact that he works at that facility and his boss says this is the practice at this facility, this is where we send everybody who asks to be in protective custody. And by the way, aside from the fact that his boss was aware of that and the jury could draw that inference, his vulnerable nature was clear because he's covered in scars from the other attacks. You know, they threw scalding hot water on him at one point. this guy. They attacked him continually. That's why he asked for PC. That's why the other people were asked for PC. They were in that unit. And so if the assistant warden, if Bush's boss knows about this, this is the practice, this is the, whether it's written or unwritten policy of this facility, that this is where we put vulnerable people. I mean, if you weigh all the inferences and facts in our favor, then Bush knew that. Bush knew that. He goes down there. He knows everybody's vulnerable. And the first person who asked him to be let out, when he shouldn't be letting anybody out because he's the only certified officer there, he knows about that policy for all the units, and he just lets them out. You can't, again, the last point I'll make, because my time's up, is the Brown case. If something can be easily avoided and you don't take steps to avoid it, that is something for a jury to consider. And all he had to do was leave the guy locked up. All he had to do was call and verify. He could have done any number of 5 or 6 things and avoided this danger, but he was deliberately indifferent to this protected class of people, and as a result, Mr. Simmons is dead. That's our argument, Your Honor.
Thank you, Mr. Hawkins. I want to thank both counsel for their excellent arguments. This morning we'll come down and greet you and adjourn for the day.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.
Remember to give us more money.
Good job, buddy. Thanks, man. See you.
We're going to turkey hunt.
Yeah, you want turkey hunt or deer hunt or both?
Well, deer hunt, so you can get some time and get acclimated to being with me for a day, and we'll wait.
Well, when I'm gonna put you in the deer stand, we'll meet you there, and I'm gonna drive away. Okay?
It's not, but.
Yeah. If I take you turkey hunting, I got to stay with you. All right, well, I see.
Man, be careful.
All right.
I want you to stand on the other side of this, because I want to get the timer as well. Stand for, no,
Right here?
stand, yeah. Right, bingo, bango. There. 3, 2, 1, and then get the whole thing. That's a good one right there.
We'll see you later. Are these people clerks up here?
Huh?
Are these people
Yes.
clerks? So are y'all in law school, or y'all at first year out, or?
Different level than year out, but kind of early career.
Okay, thank you for everything.
No problem.
All on the path to prestige. I was nowhere close to doing what you're doing.
Y'all are doing, have a great day. Have a good day.
You too.